may be seated in the courtroom, ladies and gentlemen. Sir, if you'll remain standing, I'm going to place you under oath. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, under penalty of perjury?
I do.
Please have a seat. Again, a reminder to everyone in the gallery to turn off your electronic devices. If you'd begin by introducing yourself to the jury by stating your name and spelling it for our record, please.
Yes. I'm turning off my electronic device. Yes. Thank you. My name is Dr. Michael Welner, W-E-L-N-E-R.
Ms. Murphy.
Thank you, Judge. Good afternoon, sir.
Good afternoon.
What do you do for a living?
I'm a psychiatrist and forensic psychiatrist.
Let's talk about your educational background that led to you being a forensic psychiatrist. I assume you graduated high school?
Yes.
Okay. After high school, what did you do?
I went to the University of Miami in Coral Gables and was a biology and chemistry major. And from there, I went to medical school at the University of Miami in Florida and finished my medical degree in 1988. Okay. And from there, I went to New York City and I did a rotating internship between 88 and 89 in psychiatry, emergency medicine, and internal medicine. And then I completed a residency in psychiatry at Beth Israel Medical Center in 1992. I also completed fellowship training at the University of Pennsylvania in forensic psychiatry in 1992 as well. And then I entered practice.
What is the field of psychiatry?
Psychiatry is the study of the mind and emotions and behavior.
What's forensic psychiatry?
Forensic psychiatry is where those aspects of behavior and emotions and personality intersect with different legal questions. Sometimes they're criminal legal questions, sometimes they're in courts that are unrelated to criminal law.
Are you board certified?
I am.
In what fields or field?
I'm board certified in psychiatry and I'm board certified in forensic psychiatry.
And how long have you been certified in those fields?
I've been certified since the early 1990s when I started my career in psychiatry. I board certified in 1996 and I recertified most recently in 2016.
After completing your fellowship, where did your professional experience proceed?
I began a practice of treating patients as a psychiatrist and a psychopharmacologist.
I'm sorry, what's a psychopharmacologist?
Psychopharmacology is the treatment of clinical conditions with psychiatric-related medications, like antidepressants, anti-anxiety medicines, antipsychotics. And I had a full-time position as what they call an attending physician, where you treat patients and you provide psychiatry services at Bellevue Hospital in New York City on the correction psychiatry unit.
And you had direct patient care responsibilities there at Bellevue?
I did.
After your time at Bellevue Hospital and the correctional psychiatry unit, what did you do?
I entered full-time practice in 1995 and have been in full-time practice since.
What's the scope of your practice over the years?
I had a treatment practice from 1995 until COVID. In COVID, when people started going remote, that's not how I was trained to treat people. And so that was when I moved into forensic practice full-time. But my treatment practice involved working with patients who had repeatedly violent behavior, people who didn't respond to other psychiatrists' care. And so I was referred patients by other psychiatrists who had particularly complex conditions. And then the other part of my practice was forensic evaluation and forensic consultation in various cases.
Sure. In terms of the variety of those cases, what types of cases have you consulted on or personally treated or participated in?
Well, my treatment practice was very different from my forensic practice, but my forensic practice has been very much involved in a variety of criminal court cases, cases that relate in a non-criminal perspective. I guess I'll break down the criminal in a moment, but in a non-criminal context, employment-related context of people having experiences with hostile work environment, and emotional experiences and distress as a result. In securities law relating to investment, competency to invest, competency to make transactions, competency to draft a will, as well as the criminal cases. And in the criminal context, really across I would say, the life cycle of a case, from the whodunit questions of death investigation, where it's uncertain as to whether a person, how a person died. A person may have committed suicide, a person may have been murdered, a person may have died accidentally, may have died of natural causes. And so those are questions that implicate psychiatry in a matter what's typically referred to as a psychological autopsy. And then once a person is in custody, essentially why done it? Ranging a variety of why done it questions, from pretrial questions that may relate to disputed confessions, to questions of whether someone is competent to stand trial or competent to be their own attorney, to issues of criminal responsibility of a person who may be raising the insanity defense, or who may be raising other issues where they felt that they were extremely emotionally disturbed, depending on the state, when something happened, or whether if someone was really quite intellectually limited or very impaired, whether they actually had the ability to form intent. So the law defines the nature of the case, and in different states there are different laws that bring different cases up for consideration. And included among those are questions of battered women cases where there are female defendants and they raise battered women defenses. So there are various that relate to criminal responsibility questions. And then in a sentencing context, there are various aspects of a person's psychosocial history, of biological history, neurological history that may impact sentencing after a person may have been found guilty. So pre-sentencing considerations as well.
With respect to your private practice of forensic psychiatry, are you able to provide the jury with a rough estimate as to the number of murder cases that you've consulted on in your professional career?
I would say in over 30 years, I've consulted on over a few hundred murder cases at this point.
What is the forensic panel?
The forensic panel is a practice that I started in 1998 and have been chairman of since then. It's a multidisciplinary practice of psychiatry, the behavioral sciences, forensic pathology, forensic nursing, radiology, and other medical sciences that evaluates a range of cases and involving prospective, collaborative peer oversight.
Sure. What do your current practice activities consist of? What do you do?
Well, in addition to being as chairman of the forensic panel, which is really my primary activity, probably my activities involve actually working on cases, which is what brings me to here to you all today. I supervise other physicians in the course of their conducting evaluations. I conduct research, and I teach, and I write. So it depends on the month, but that's the breakdown of my practice time.
Okay. You said that you engage in research. Are you published in any areas?
I've published in a number of different areas and continue to contribute to the psychiatric and medical literature. The areas of my principal research have been, I've researched and developed a method for peer review to promote the integrity of forensic science that's applicable across forensic sciences. I've researched and optimized and published on something called the depravity standard, which is an evidence-based way for determining the most blameworthy of crimes for application in a criminal court. I've also researched disputed confessions and published on that. Have researched mass and spectacle homicide, have researched and published on drug-facilitated sex assault, have researched on cult leaders and their vectors of influence, as well as the assessment of homicide and the maturity of those young people who commit homicide, as well as fetal abduction.
Okay, wow, thank you. That is a broad range. Let's talk about a few other things. What is the New York Supreme Court's highly qualified independent psychiatrists list or panel?
The New York State Supreme Court maintains a list of individuals who it deems has the qualification to work on certain cases within the New York court system where an independent psychiatrist that has no, that's not brought in by a prosecutor, not brought in by defense attorneys, but a question may come up, a psychiatric legal question may come up, the court wants to be informed by it, so they maintain a list of people that they may reach out to and involve in those particular cases.
Do you have any association to the Mount Sinai School of Medicine?
Yes.
What is that?
I'm a clinical professor of psychiatry at Mount Sinai School of Medicine.
Can you explain the difference between clinical psychiatry and forensic psychiatry?
Clinical is a treatment context. So clinical, psychiatrist that you see for a given condition, and a psychiatrist hears things and is supposed to be hearing things exactly as you would say them to be. So if you were to come to me and give me a variety of symptoms relating to anxiety, I would take what you have to say at face value because you're coming to us well. In the forensic context, and so you operate under the presumption of trust, you know, and everything you're hearing is everything as it is. And the forensic role, you operate under the presumption of caution because someone's a litigant, they're involved in a case. And so they're hearing things the way they want you to hear them because you may one day be in court and be asked to give testimony. So by virtue of that, you're relying upon evidence and you're relying upon other sources that can give you a sense of confidence that what you're hearing is exactly as it is. And those kinds of responsibilities and challenges don't exist in the clinical world. It's much more linear. I don't feel well, just as it is when you see any doctor. I don't feel well, I'm coming to get me well, please get me well, end of story.
So when you're operating in the forensic psychiatric realm, what types, just kind of broad categories of corroborative evidence might you review or rely on?
Well, it depends on the question that's being asked. So if it's a question of competency, if there's a question of competency to stand trial, well, we're in mid-July. And so I would rely upon information that would inform someone's mental state in the middle of July. A person may have a history of psychiatric problems or may not have a history of psychiatric problems. They may have changed. There may be certain circumstances that impact that individual's competency. So I would be looking at a range of objective information, sometimes subjective, but objective information, whatever one can gather, either from documents or sources who are witnesses, who've observed things, that can help to converge all of that data, give me some sense of confidence that I have the ability to address those particular questions. Can a person maintain his behavior in court? Does he have a sense of reality? Can he conduct his emotions properly? Are his thoughts organized? Is he rational, right in the here and now, to participate in this court proceeding? But that may be totally different from the nature of the demands that I might have in a disputed confession case, in which case I would be focusing on. And let me
just stop you for a moment. It's okay, Dr. Welner. Let me just stop you for a moment and ask more specifically, in cases where you may be asked to answer questions related to interpersonal relationships, or in a murder case, or a case that is in a criminal trial that you may be consulting on, just what broad categories generally would you rely on for evidence for your review?
Well, in those kinds of questions, you really want to know, the best way to boil them down is to appreciate them as what was the person's mental state at the time of the offense. So you're looking at that moment in time, or right before it and right afterward. So any kind of documentary evidence, and any evidence of the person's function, any evidence of the person's communication, how they were relating and what they were saying, the kind of data that one can extract from a smartphone or one can extract from a phone, or sometimes digital evidence that shows a person's movements or transactions or decision-making or communications. So anything that informs a person's function and a person's decisions around the time of the offense, and how that may answer the psychiatric questions in particular that are posed.
Okay, thank you. You've obviously been called during the state's case. Do you exclusively consult with prosecution, or have you consulted with defense in cases as well?
I consult to both prosecution and defense.
Okay. Have you ever testified as a witness on behalf of the defense in cases?
I have testified as a witness on behalf of the defense.
Have you ever consulted on cases involving a perpetrator or alleged perpetrators who are intimate partners themselves?
I have.
How many times have you testified as an expert witness?
Well, I probably testify about twice a year. Most of the cases that I consult on never get to court. And I believe this is the only case that I've testified on this entire year. So you multiply that by 30 odd. I think earlier in my career, I probably testified a little bit more frequently. So I would say probably in the neighborhood of 100 times at this point.
Have you ever been qualified in the realm of psychiatry?
I have.
Have you ever been qualified in the realm of forensic psychiatry?
I have.
Have you ever not been qualified when tendered as an expert in psychiatry or forensic psychiatry?
I have not.
In the course of your professional activities, have you ever consulted on cases where allegations of domestic violence were included in the history?
Yes.
Okay. Have you followed, or do you maintain or stay up on the research that has surfaced regarding interpersonal violence and its relation to complex crimes?
Yes.
Your Honor, at this time, I tender Dr. Welner as an expert in psychiatry and forensic psychiatry.
Any objection?
No further objection, Judge.
Dr. Warner is admitted in those two areas and allowed to express his opinion in those limited areas. Ms. Murphy.
Thank you. Let's turn to this case. Very generally, what general questions have you consulted on to try and answer in this case?
I was asked to offer an opinion on the dynamics between Kiara McCulley and Isaac Apodaca. I was asked to offer input about the forensic behavioral science constructs and areas of study that were illustrated in the records of their relationship. And I was asked to offer an opinion about the qualities that are documented about Kiara and Isaac that would have expressed themselves in this event that we're here about today.
In consulting on this case, I won't ask you to bullet point each individual document, but what categories of evidence did you review?
I reviewed the criminal complaint. I reviewed the police investigative reports. I reviewed the 911 call of Linda Montoya, the 911 call of Isaac Apodaca. I reviewed the approximately 15 hours of Facebook messaging between Isaac Apodaca and Kiara McCulley. I reviewed the body-worn camera by police officers when they encountered and interacted with Isaac Apodaca in arrest and also in the transport. I reviewed the autopsy report, the autopsy photographs, crime scene photographs. I reviewed Grace Jennings' social media data that was available. I reviewed Isaac Apodaca's Facebook information that was available. I reviewed Isaac Apodaca's criminal history.
Your Honor, let me just stop you there. And And when you say that, you mean as it relates to the charges in this case specifically, is that correct?
Well, I didn't know that it did relate, but I reviewed it because you don't know whether it relates unless you actually review the history. That's how you know whether things are or are not relevant.
So you
Your Honor, can we approach?
Come on up.
And just to clarify, when you just mentioned the words criminal history, you meant that as it related to the April 2022 incident and then this case as well?
That's correct.
All right, thank you. Did you?
I haven't finished my answer.
Yes, let me just get there. I'll ask a couple just more pointed questions. Did you review the actual phone extractions in this case?
Yes,
Okay. And did you review some recorded conversations, phone conversations?
yes, I did.
Thank you. Are there any other categories of evidence that you reviewed that I've missed?
Yes. I reviewed the law enforcement interviews of Isaac Apodaca, of Kiara McCulley, of Ms. Montoya, Ms. McCulley, Ms. Montoya with, I believe, her husband, Jimmy, Roma Resendez, the interactions with Roma Resendez and Arlo, Catherine, and I believe it was Eliana. I reviewed pretrial interviews of Kiara McCulley, pretrial interviews of Ms. Montoya, and also Kiara's mother. And I conducted a number of interviews of witnesses myself. Oh, I also reviewed a psychological evaluation conducted of Kiara McCulley. And just remembering, web searches that had been done by Isaac Apodaca around the time of the event.
Right. Thank you. Is it customary for you to review, or for a forensic psychiatrist to review communications of people that are made close in time to an event?
Yes, it's very important to do so.
And why, generally speaking, are those communications between two people who may be involved in an event important to you?
Well, because there are various ways to explain an event. And if you have that information, then you're able to inform what happened immediately preceding an event, and you can identify any kind of triggers, potentially, to the event. You have an opportunity to understand how people relate, especially if they were both involved, whether there was a leader, whether there was a follower, what the nature of that is. You can gain understanding about the motive of the offenders. You can get an understanding of the victim's involvement in what transpired. So that's an example of what you can inform by the communication, and you don't know what you're going to learn until you actually study it.
What, if any, general information, and just being very general and short in your response, have you obtained regarding sex work as it relates to Kiara and Isaac?
Well, that there was an extended period during which Isaac was compelling Kiara into sex work, and that continued even after Kiara's mother found out about it and directed her to stop and directed him to stop.
Is there any research on intimate partners where one is drawn into sex work by the other?
Yes.
Okay. And is there a professional term used for that dynamic?
Yes. It's called coercive control.
How is coercive control understood in the forensic psychiatric community in terms of sex work being facilitated by an intimate partner?
Well, the person who's compelled into sex work is dependent in the relationship to the point that they lose what we call agency, and that is they really assert their choice. So the person has essentially a loss of personal agency, and they're pulled to be responsible for the economic betterment of somebody who was otherwise able-bodied, but they're essentially supporting that individual. Within that relationship, the person doing the sex work relates to it and relates to what's going on as this is just an extension of love and intimacy. This is just something I'm doing for the relationship. And that by virtue of the dominance of the other individual, the person compelling that, and the power, and in some instances the economic situation, in other instances the secrecy of what's going on, and in other instances traumatic experiences, that's what keeps that person from leaving the situation, and it maintains the situation as it is. And it's appreciated under the broader heading of domestic violence because it involves the degree of control and the expression of it that it does.
And without going into detail, understanding well into the case, but is that history or that element of coercive control present in the case through your review of it?
I think the records and the evidence demonstrates that was present here.
And you referenced a concept of economic control. Is that a concept that you, in your opinion, have seen reflected in this case?
Sure. And if insofar as the money that Kiara was earning was basically going to Isaac for his disposition and his making choices, then he essentially had economic control over the situation.
You talked about traumatic events being reflected and sometimes in the coercive control dynamic. Do you see that element present in this case, in your opinion?
Well, one instance that I know about was that she was raped in the course of doing this sex work. And that happened in October 2021.
And what concept would that lead you to consider as an element in this case?
Well, I think that it's in the context of this coercive control, it's these kinds of traumatic experiences that contribute to just the nature of the connection, the nature of the bond. So I think that it's just consistent with the other aspects of the coercive control that were present within this relationship.
And so you mentioned trauma bonding as a concept. Then, what does that refer to in the context of intimate partners, where one is inducing the other to participate in sex work?
Well, trauma bonding has a relationship to this in the sense that it involves a relationship between an abuser and a victim, and there's a power differential. One person has much more power within the relationship than the other. The distinctive features of trauma bonding that make it sort of its own entity is that within the relationship, the dominant individual uses positive experiences and negative experiences to reinforce control within the relationship. But the person who's more submissive and follows interprets all of the good experiences with gratitude, but interprets the bad experiences and the experiences that are reflective of abuse as something that she deserves. And they react to it as a matter of self-blame. And what distinguishes trauma bonding is that the submissive person internalizes the perspective of the dominant person as opposed to advocating her own.
So I'd like to turn for a second and talk about the relationship through your review of the records and things that you've heard in this case about the relationship between Kiara and Grace as it existed in October of 2022.
Yes.
Fair to say that you would categorize this as antagonistic?
Yes, hateful.
In your review of this case, did you see evidence or observe information that indicated the presence of violent fantasies in this case?
Yes.
Okay, and why is that relevant to you?
Well, this ended in a murder. And so going back to the notion of mental state at the time of offense, one of the things that I have to consider is whether this is something spontaneous that just erupted and happened unexpectedly, or whether it was something that could have been otherwise anticipated.
Do the records reflect, or the things that you've reviewed, reflect an understanding that Kiara was emotionally volatile?
Yes.
And let me ask you to define a term. What's gaslighting mean?
Gaslighting it's a term that actually gets a lot of use in popular communication, but it's actually also a clinical term that's attracted study within the behavioral sciences of domestic violence and intimate violence and intimate abuse. And what gaslighting on the clinical level refers to is the mental manipulation by a dominant person over an intimate partner in such a way that they question their sense of reality, and that they question a sense of whether something actually happened that did not, as a result of someone else's manipulation. That were it not for that individual, they would not have any reason to question how they think about things in their own sense of what's true or what's not true, and that the person is applying a gaslight to essentially instigate those kinds of feelings and ideas that a person would never otherwise have contemplated as true or wasn't considering.
Just started raining. In applying the term gaslighting to this case, can you generally speak to some elements that you may have observed that indicate the presence of a gaslighting dynamic?
Well, I think the evidence demonstrates that that Isaac Apodaca was gaslighting Kiara McCulley over the idea that she had been gang raped by Grace Jennings a number of years earlier, and that over time she came to believe it or somewhat believe it, and he reinforced it by suggesting to her that he had seen videos on the dark web and that he thought resembled her, the victim resembling her, but would reinforce this idea that Grace Jennings was responsible for having orchestrated a gang rape of her some years earlier.
You reviewed the social media messages between the Null Void and the Froggy McCullough accounts. Is that correct?
I did.
Okay. And by your count, how many hours did those messages go on?
I suppose over 15 hours.
And in those communications, what did you observe Isaac Apodaca via the Null Void account do regarding Kiara and Grace?
Over the course of 15 hours, Isaac Apodaca was offering various approaches of persuasion or inducement to get Kiara to kill Grace. Persistently so, relentlessly so.
Can you give some examples to the jury, please?
I'm going in even order of sequence because she responded. She resisted, and then he would respond. Use a dull knife. It cuts like butter. She'll die instantly. I'll burn all the mess, and I'll go out and buy a new bed and new blankets. You always told me, communicating to Kiara, don't be a pussy. You have to start, and then I'll help. Just aim. Why are you holding back? I can't help you. I can only coach you. She's the one who sold you into sex trade. She made you feel horrible about the color of your skin and your beliefs. Just swing and don't regret your aim. I can get Christian to help. We can go to the barn. Nobody will hear her screaming because the walls are soundproofed. Those are some examples of persuasion. You wanted to kill her since 2020. What's holding you back? And others. These are some examples of the persuasions, but the inducements were, now that's different. I would draw a distinction between the two.
I was just about to ask, so you mentioned the persuasions. What would the inducements to commit the murder be?
Well,
I guess, first of all, what does it mean what is an inducement?
Well, what do I get out of this? Okay? What do I get out of beyond just satisfying revenge because she gang raped me and she made me feel bad and all of these things? Well, what do you materially offer? So what he materially offered was for her to advance in this group ghost, that she'd be admitted and she would grow in ghost, that she would get extra points, that she would get perks on the dark web because this was her first murder, and that she would get a rush of adrenaline from doing it. Those are ones that I can think of.
Thank you. Was there anything notable about the way that Null Void or Isaac Apodaca's account was communicating with Kiara?
Well, he clearly knew her areas of sensitivity. You know, he knew about the relationship with Grace. He knew that she was that she believed that she had been gang raped. He knew that she had violent fantasies. He knew that she wanted to join this group ghost, and he had claimed that he had killed 40 people and that he was a vigilante and that he was killing sex traffickers and that this was her opportunity to be part of something, and knew that she wanted to be close to him and knew that she felt that she needed to be close to him, and that translated into various aspects of their relationship and her dependence, her psychological dependence otherwise. So somebody who didn't have a sensitivity to her at a deep and emotional level would not have been able to be so targeted in responding to some of her resistance, because these suggestions that he was offering were in response to her resisting or saying, I can't do this, or I give up, or I'm tired, and then he would come back and he would say something else.
You just spoke to some to evidence of resistance. Can you give, I'm not going to ask you to list everyone, but can you give some of the elements of resistance that you observed from Kiara in those messages?
Well, over 15 hours, I can't remember everyone, but again, she said, well, what about the mess? What about the mess that I'm going to, so he says, well, I'll burn the mess and I'll change the bedding and I'll buy new blankets. And so can you help? And of course he says, well, I can't help because this is a ghost thing, so I can't help. I can only coach. Getting guidance about how to do it. And her saying that again, there were times that she said, "I give up. I'm tired." And at one point she said, "I physically can't do it and you won't do it." And she said, once this happens, there's no undoing it. So these are various examples of at some point she suggested, well, why don't you grab the knife and then try to stab me and then miss? These are, there are many more within the 15 hours, but this is an example of how she would come back and then he would respond with something and then back and forth.
Sure. What is the significance to you from a forensic psychiatric perspective of Kiara asking, make me angry or make me mad, provoke me to be enraged? Those sorts of statements. Why is that?
I mean, she said at some point, she said, remind me of what she's done to me. So if the experience with Grace was that traumatic, then she wouldn't need to be reminded, especially in the context of her being persuaded to carry out this killing. So she actually asked him that, and it also reflected that she wanted to be roused to anger to bring herself to a point that she could carry out a murder.
We see in the messages at some point that Isaac seems to suggest waking Grace up and throwing her out kind of as an alternative to killing her. Do you recall that kind of line of discussion?
I experienced it as a discussion that Isaac came up with an idea of saying, you're throwing both of us out.
Operation Fake Kick Out. Do you remember those words?
Operation Fake Kick Out. And so this wasn't to as an alternative to the murder. This was in order to in some way create a conflict or a confrontation during which there'd be an encounter, because there was no confrontation the whole evening. There was no confrontation between Grace and Kiara before they went to sleep, notwithstanding the relationship. During the evening she was there, they talked. Kiara's recollection was that she tried to make her feel better because she found out that she had just broken up with a fiance, and then she was able to feel some sense of compassion. So this was transpiring after all of that, and so she couldn't bring herself otherwise. So then they were talking about, well, exactly how could this be orchestrated? And in this context, Isaac came up with the idea of saying, just say you're kicking us both out.
And then did Kiara seemingly start to go along with the notion of a kick out?
Isaac left, and so she followed his suggestion.
Okay. What was the final message that was you reviewed in the Facebook messages?
Isaac told Kiara that Grace had admitted to all of this traumatic activity, to having orchestrated the gang rape, had admitted it to him.
Is that relevant to you from a forensic psychiatric standpoint?
Well, it is, because it really was the kernel of her homicidal fantasy. That the rage that she generated toward Grace, or that she was able to maintain, because they hadn't had contact for a long time. But the nature of that rage had been cultivated through this false story of a gang rape, and that was the source. So it went right to the source of what would be the hot button of her rage.
So, Dr. Welner, based on Kiara and Isaac's personal history, the evidence you reviewed in this case, what is your ultimate opinion you reviewed in this case, what is your ultimate opinion on how that relationship or those relationship dynamics played a role in the murder of Grace Jennings?
Well, in various respects. First of all, he was dominant and controlling. She was very dependent. He had various homicidal fantasies, was saying that he was running a vigilante gang, had killed 40 people, and making those representations that Kiara believed. She had extreme rage towards Grace that he had cultivated in her. Isaac, who's aware of the intensity of all these feelings, brings Grace over to where they live without getting her permission and just says she's coming over and puts her right there in that situation. Notwithstanding that, even though she objected to it when in the course of their correspondence, their recorded messaging, she went along with it, and they had an uneventful evening before they ostensibly all went to bed, but Isaac and Kiara continued to message one another. He had the demonstrated capacity to persuade her to do anything. He not only was able to persuade her to participate in the sex trade to the point of exposing her to risk. She was raped, but he was able to persuade her to continue even after she was raped in the sex trade. So he had the capacity to persuade her to do anything, as well as go along with his plan of him being in the home, living there, when clearly her mother objected to it. And so extreme was that emotional dependence that she had that even after the April 22 incident, and he was able to manipulate her into dropping charges because she didn't want to endanger the relationship. And he was asked to leave the home, and she allowed him to come back. And she was so intense in that level of dependence that when there was any consideration of him leaving that home, leaving the McCulley home, she told her mother, I'll go live out on the street with him. So you have those things playing themselves out, and I think that that's how they converged that evening.
A moment, Your Honor.
Yes.
Pass the witness.
Judge, can we approach?
Come on up.
Just a couple questions, Dr. Welner, and I want to speak in general terms, not necessarily about the individuals involved in this case when I ask these two questions.
Okay.
In a relationship such as you've described from a theoretical point, coercive control and these dominant and submissive power dynamics, why does someone take the dominant stance and want to engage in these types of dominant behaviors?
Well, the way you phrase the question, I'm going to try to answer it as concisely as I can.
Okay.
But please understand if I can't, it's because I'm just trying. All right.
Understood.
Now that said, it's not theoretical. This stuff has been researched. So I'm not talking about theoretical construct. The notion of coercive control has been studied and researched. So you ask the question of why does the person who is a dominant individual do what they do? That's unique to the individual. So in other words, the fact that the history of Mr. Apodaca's homicidal fantasy is not something that you find in every dominant individual. So how it expresses itself is different, and it converges with the expression of the dominance. Not every individual who's involved in this kind of intimate partner relationship is going to compel their partner into sex trade. That happened here. In other instances, other things happen.
Let's stay to the general construct of individuals who have a dominant coercive control aspect. What benefit do they derive, generally speaking, not necessarily specific to Mr. Apodaca or Ms. McCulley's case? What are the general types of benefits one might derive?
The psychological benefit is the satisfaction of control over another individual and the absolute nature of that. The more control one has, then the more one feels a sense of satisfaction and comfort.
Thank you. Pass the witness, Your Honor, and I'll hand this to the court reporter.
Cross-examination, counsel.
Good afternoon, Doctor.
Good afternoon.
How are you?
Nice to see you again.
Fly in from Palm Beach?
I've actually I flew in from Fort Lauderdale.
Fort Lauderdale.
Yes, sir.
All right. And I'm going to ask you just some general questions. A lot of what you're testifying to is based on generalities, correct?
No, it's based on the evidence of this case and the scientific study of the constructs that I'm referring to.
Okay. But those scientific constructs are somewhat generally applied in different cases, correct?
No, they're applied based on the specificity of the evidence and whether it fits. If there's no applicability to the components of the coercive control that I discussed or the trauma bonding, then, these are very specific qualities that I'm referring to as they approximate here.
Okay. And you have been retained by the prosecution to provide analysis in this matter, correct?
Yes, sir.
Okay. And you are a licensed practicing forensics psychiatrist?
I'm a licensed psychiatrist, yes.
Okay. And one of the pillars of reliable psychiatric evaluation is direct face-to-face evaluations of the individuals in question, correct?
It's certainly a pillar for a diagnostic evaluation. If one wants to give a diagnosis, then it's a pillar to evaluate someone face-to-face.
You have never sat in a room with the defendant, Isaac Apodaca, correct?
I have not examined him.
You have not sat in a room with Kiara McCulley, correct?
I have not.
Okay. So you have never administered any sort of psychological diagnostic testing or assessments directly to Mr. Apodaca or Ms. McCulley, correct?
I have not.
Okay. Because you have never examined Mr. Apodaca, you're unable to provide a formal diagnosis regarding his mental state, correct?
That's correct.
Okay. And to be clear, you can't testify with any degree of medical or psychiatric certainty regarding the specific individualized mental health or psychiatric conditions of Mr. Apodaca.
I can testify to what I've testified to, but I can't testify to a diagnosis. You can testify to a diagnosis if an evaluation is not possible and it was not possible in this case. However, the reason that I'm not testifying to diagnosis is because in addition to not having access to Mr. Apodaca or Ms. McCulley, I don't have a complete medical record of their history, and so I don't have anything to otherwise inform it.
Okay. And if I could just ask you, if I was going to ask you this in the beginning, but if you could just answer
Sure.
when it calls for a yes or no answer, if you could just answer as such. And there may be
I'll do the best I can.
So,
Yes, sir.
if you could, that'd be great. Okay. And then, so basically, your entire perspective on this case is based on secondary documents, third-party materials provided to you, correct?
It's based on, yes, it's based on the historical evidence record.
Okay. And you basically relied on materials that were specifically curated for your review, correct?
I don't know that they were curated. I asked for the complete set of documents that would inform an understanding of the time of the offense.
Okay. Now, you've never observed Mr. Apodaca interact with anyone, correct? Other than anything involved in the file of this case?
Yeah, with respect to the file of this case, I observed what I observed, whether it be the body camera, whether it be the interviews with law enforcement. Those are things that I did watch video of, but otherwise, it's limited to that.
Okay. So you're basically offering opinions about the psychological dynamic between Mr. Apodaca and Ms. McCulley.
Correct.
Okay. But you never sat face to face with Ms. McCulley to get her perspective directly.
I did not. I was relying upon.
Yes or no?
I did not.
Okay, thank you. And you never got Mr. Apodaca's?
Your Honor, may we approach?
Yeah.
Counsel, you may continue.
Thank you, Judge. So basically, you never got the perspective directly from Ms. McCulley or Mr. Apodaca, correct?
The only perspective that I
Yes
got.
or no,
I got their direct perspective in the other interviews that they conducted that were recorded.
Okay. And you never heard Ms. McCulley directly sitting in a room, face to face. You never heard her describe the relationship between her and Mr. Apodaca, correct? Yes or no?
I did in the context of reading her pretrial interview and the other interviews that she did for this case. She was, they were detailed and they were transcripted.
Okay, but doctor, you never sat down in a room with Ms. McCulley or Mr. Apodaca to discuss, for example, the dismissed domestic violence case from 2022.
I did not.
Okay. You never sat face to face with Ms. McCulley, yes or no?
I did
Doctor,
not.
no, I was getting to a point. You never asked Ms. McCulley if she felt psychologically controlled by Mr. Apodaca.
I did not ask her that question.
Okay. So you are making your analysis and assumptions based on the documents that were presented to you in this case, correct?
I'm making my analysis based on the documents and based on a range of interviews that I conducted of contributing witnesses, which included people who are acquainted with Kiara McCulley and with both of them.
Okay. Now, you have stated that the dismissed April 22 incident is relevant to the dynamic between the two. Yes or no?
Yes.
Okay. And you stated that this prior incident shows that Mr. Apodaca had psychological control over Ms. McCulley, correct?
It contributes to.
Yes or no?
I don't believe that that was exactly my testimony, but what it does illustrate to me, if I can restate my testimony, is that it illustrates that Kiara's dependence on him was such that after a significant assault such as it was, that she prioritized maintaining the relationship, and she also prioritized keeping him in the home.
Okay, but doctor,
That's what my testimony was.
that incident was, that case was dismissed, yes or no? Based on your review?
Yes, the case was dismissed.
Okay, and you don't know, you have no further information in conversations with Mr. Apodaca or Ms. McCulley in regards to the circumstances of why that case was dismissed, correct?
I have an understanding from the records of why it was dismissed.
Doctor, my question was, you don't have an understanding of that directly firsthand from Mr. Apodaca or Ms. McCulley?
I did not speak to either, and I did not have access to either of them. I spoke to the people I had access to.
And you've also previously stated when we did a pretrial interview that the allegations in the April 22 case were different from the actions in this particular case. Correct, doctor?
That's correct.
Okay. And when it was me who asked you in that interview whether it was character evidence, you didn't deny it, did you?
You'd have to show me the transcript in the context of that, because we did talk about quite a number of things.
Okay.
I'd want to see that what I actually said.
Okay. So you are basing your opinion based on maybe a prior charge that was filed and dismissed, correct?
I'm basing my opinion on her psychological dependence on various aspects of her psychological dependence, including how that case was handled, and including her not moving forward with the complaint, which is how it came to be dismissed.
But you don't have any knowledge of whether she didn't move forward with the charges or whether the charges were bogus, correct?
I have knowledge that when police called her to speak to her about it, that Isaac was in the room.
Well,
she declined to speak to them
Doctor.
without telling them that he was in the room when they called her.
Doctor, can you answer my question, yes or no? You did not speak, you did not get a first-hand account from Mr. Apodaca or Ms. McCulley about what actually happened there in that April 2022 incident?
I didn't get access to speak to either of them about it.
Okay. You stated stuff like Mr. Apodaca had invited Grace without getting permission from Kiara, correct?
That's correct.
Okay. All of this information that you provided in making your assessment were, again, based on your review of documents and videos, correct?
The materials of this case, yes.
Okay. So you're claiming to know Mr. Apodaca's intent based on your review of a file without speaking to him directly?
I don't believe I've testified about his intent.
Okay.
I've testified about the dynamics between the two of them, the constructs implicated by the forensic literature, the behavioral science literature, and the qualities of each of them that related directly to this event. In terms of his motivation, I haven't offered testimony about it.
Okay. And you, one second. Dr. Welner, based on your review of this case, there is no DNA evidence linking Mr. Apodaca to Ms. Jennings' death, is there? Yes or no?
Based on my understanding of the case, that's correct.
Okay. And there is no physical evidence that Mr. Apodaca touched Ms. Jennings, correct?
That's my understanding.
Yeah. Could you answer yes or no? It'd probably be better for the record too.
Well, you asked me, there's no evidence that he touched her, and I don't believe that that's what you're getting at. No, there's no evidence that there's no DNA, there's no physical evidence that he issued an assaultive or lethal blow.
Yes or no, doctor? There is no blood spatter, from what you understand, on Mr. Apodaca's clothing, correct?
That's correct.
Okay. Yes or no? There is no forensic evidence placing Mr. Apodaca at the scene during the actual stabbing, killing, correct, doctor?
Well,
Yes or no, doctor?
that's not true.
Yes or
Because,
no?
well, the answer is no. There is forensic evidence.
Okay,
There's no physical evidence, but there's forensic evidence.
Okay. Placing him at the scene while the stabbing is occurring?
While the stabbing is occurring, no.
Okay. That's
Only
what I'm-
around the time.
Okay. Dr. Welner, you don't actually know what Mr. Apodaca expected would happen when Grace was invited over, correct? Yes or no?
It's an interesting question.
But I asked for, I mean,
No,
can you answer it
I have to think about it before I answer it, because I think only he knows what he was capable of persuading her to do, but I don't know what his objectives or anticipated outcome of that night when he invited her over. That's correct.
yeah, okay. That answers it well. Thank you. You know, Dr. Welner, a major part of your opinion rests on the review of possibly some text messages?
You mean the Facebook messaging?
Yeah, Facebook messages?
It certainly contributes to my opinion, and it was borne out from various aspects of what I got from the documentation and the interviews and my own interviews.
Okay. So basically what you've been reviewing is what we've been going over here this week, correct?
Objection, Your Honor.
I can move on.
Yes,
Understood.
yep, move on.
Okay. Okay. Dr. Welner, I'm now going to shift over towards interrogation tactics, coercion. In regards to interrogation, you had stated that that's an area that you have expertise in, correct?
Yes, I've published in that area and I've researched some.
Okay. And in regard to that, what you did review the interrogation in this case?
I did.
Okay. And what specific interrogation techniques did you identify as having been used during the interrogation?
I think that the detective, after giving him an opportunity to elaborate, confronted him with the Facebook messaging and the contradictions of his account.
Okay.
And that was essentially a principal technique that I observed, that he was asked to explain and to reconcile the contradictions in his account from what was showing up in the Facebook messaging.
Okay. And you are familiar with the read technique, correct?
I am.
Of interrogation?
Yes.
You're also familiar with the piece model?
Yes.
Okay. Can you explain the read technique of interrogation?
Well,
Relevance?
I'll allow it.
I mean, the read technique is an approach in which various techniques are employed in order to bring a suspect from denial to confession. The peace technique offers all of the qualities of the read technique, but does not employ confrontation.
Okay. And then are you familiar within these methods in regards to minimization tactics?
Yes.
Okay. Minimization tactics were employed, were utilized in this interrogation, correct?
I can't say that they were. Minimization refers to the diminishing the seriousness of what happened. I don't recall the detective diminishing the seriousness of Grace Jennings' murder. Minimization is diminishing the consequences of what's going to happen to somebody, and I do recall that at the beginning of the interrogation that Mr. Apodaca was told that he wasn't a suspect. And I believe that at the beginning of the interrogation he may not have been.
Okay, Okay, so without going
But
in-
I think that when everything came down and he was being actually presented with what was in the Facebook messaging, which then became accessible through the fortuitous access to his phone, then I don't think that he was told that he would not be held criminally responsible in exchange for, or that he would be treated in a diminished way, which is what legal minimization refers to.
Okay, so I'm going to go through some of the exact parts of the interrogation.
Sure.
In the beginning, where the detective discusses Halloween and what he's going to be doing for Halloween. Do you remember that part?
Sure.
Okay. That could be an implied promise tactic, correct?
Can you show it to me? Because in my own mind, I'm inclined not to agree with you, but you may be right, and I want to see what you're referring to.
Okay. Let's do this instead of having to, if the detective were to talk about Halloween plans,
Yes.
okay, would that, early on, in the interrogation, what are your plans for Halloween? Are you going to dress up? All that. Would that be indicative of a false promise?
No, that's referred to as rapport building.
Okay.
And that's an interrogation technique.
But that is an interrogation tactic.
Yes.
Okay.
You build rapport with someone because if they're comfortable, they'll talk to you. You hope.
Okay.
But they're less likely to talk to you if no rapport is built.
Can you discuss maximization tactics?
Yes.
Okay. Can you explain what that is?
Maximization is one amplifies the seriousness of an offense. And I can hardly imagine how the murder of Grace Jennings, such as it was, could be maximized. I mean, it was what it was.
Okay.
And I meant to say over amplification.
There's no question. Wait for the next question.
Thank you, Judge. Now, a long interrogation, would that be concerning in regards to a possible coercion?
It depends what happens during the long interrogation. It depends on the conditions of an interrogation. If a detective or police officer creates coercive conditions within an interrogation, it doesn't have to take too long. And length of interrogation can be affected by any range of factors, but it doesn't create coercion. It creates a lot of boredom, may contribute to a suspect falling asleep because they have to wait a long time.
Okay.
But no.
And generally, is lying a tactic in interrogations?
You mean when officers lie to a suspect?
Yes.
Some officers will lie during interrogation. It's not as commonly used if you look at surveys of police officers, but it's some officers will lie and see where it goes and what it elicits.
Okay. Creating a narrative of guilt that they want the suspect to adhere to?
It's not an interrogation tactic
It happens
because
in interrogations?
it may at some point that there are various theories that may get tested out, but it's not so much a tactic as it is something that happens in interrogation. In the read technique that you speak of, they're not taught to create narratives, they're taught to elicit input. So if it's something that a detective does or law enforcement does, if anything, it's not necessarily encouraged because it may prevent other information from coming to light. But it's not something that contributes to a coercive atmosphere. It's just a qualitative technique issue.
Okay. Psychological vulnerabilities of a subject, again, that's something that you would have to interact directly with the subject to know about, correct?
You can get a lot of historical data about someone's psychological vulnerability in an interrogation. The opportunity to examine somebody doesn't reflect on how they were at that time. and someone that you see at a point in time after they've been arrested and been in custody may be very affected in various ways and may not have had the vulnerabilities that they had at the time of interrogation. And that's also to include strengths and the ability to resist somebody's questioning. So an assessment of vulnerability, it refers to the assessment of a person's vulnerability to give a false confession to a crime that they did not commit. But it also encompasses looking at the strengths that a person has to be in an interrogation, whether they're guilty or innocent, and to parry away any efforts from a detective or an officer to get information from them.
Okay. And did you interview any of the interrogating officers?
I did not.
Okay. One second, Judge. Nothing further, Your Honor. Thank you.
Redirect.
Yes, Your Honor. Dr. Welner, let's start where defense left off and asking about interrogation techniques and false confessions.
Yes.
Okay. What is a false confession?
A false confession is a confession that somebody makes to a crime that they could not possibly have committed. Because, for example, let's say that you confess to a murder, but that murder happened when you weren't in Santa Fe, but you were in Fort Lauderdale. Well, that would be a false confession. Or you confess to a murder.
Doctor, don't refer to specific jurors in your examples.
Okay. Let's say that someone else can confess to a murder or a sex assault, and the physical evidence of that sex assault demonstrated another person's bodily fluids inside someone. And so the nature of what was physically described could not possibly have taken place. So it's a confession to an event for which the physical evidence, and actually not just the physical evidence, but the digital evidence, and that was the testimony I gave earlier about forensic evidence, many kinds of forensic evidence, wholly makes it just impossible that the person could have participated at all.
That goes to my next question then. You did differentiate between forensic evidence and physical evidence. Can you just explain that difference?
There are many kinds of forensic evidence. There's the evidence that we rely on in behavioral sciences is human evidence. When I interview someone, it's human evidence, and I take it in. There's physical evidence from the DNA that's been referred to. There's digital evidence where there's camera, there's photography, and you can prove that someone was where they were in a particular place. There's documentary evidence, which is it is what it is, and it was created when it was created, and was said what was said. So these are various forms of evidence that converge to inform our understanding of what it is that we're supposed to evaluate.
To you, from a forensic psychiatric perspective, is the lack of physical evidence that implicates Isaac Apodaca, in other words, the fact that his DNA isn't on the sword or his fingerprints aren't on the sword, is that forensically, psychiatrically relevant to you in your assessment of the relationship between Kiara and Isaac?
No, I was asked to evaluate the dynamics between them, I was asked to evaluate the psychiatric and psychological constructs that might have relevance, and I was asked to evaluate the qualities of each and how they culminated in this event.
You were asked on cross, and then you wanted to clarify something. I just wanted to give you the opportunity to do so. You were asked about the concept of maximization in a interview of a suspect, and you said something about amplification versus over-amplification. Can you just clarify what you were talking about?
Well, I did not want to misspeak. If you, an example that I can refer to is if someone is being questioned about an alleged physically or sexually inappropriate act that exposes itself to certain charges. Maximization would be, you're going to go to prison forever, you're going to get life for this, or you're going to get 50 years for this. And so you're amplifying the significance of the legal significance of the event in order to impact the suspect to think that the potential consequences are greater than they are. So you've over-amplified it. So my point is, you can't over-amplify this murder. It is what it is. It's not, it doesn't have relevance to the context in which maximization is studied and applied.
Yes.
Just to be clear, you're not making any diagnoses in this case.
No.
And you had the opportunity to observe Kiara McCulley's testimony today?
I did.
And just generally speaking, did those observations factor into your opinion, the opinions you've already testified to in this case?
Yes, the information that she provided and my observations, yes.
A brief moment, Your Honor. And then just finally, in terms of the defense questioning about coercion and the source of the interview, in your review of Isaac Apodaca's interview, were coercive techniques utilized?
No.
Thank you. May we just approach on that, Your Honor?
Come on up.
Dr. Welner, is it unusual for you to make determinations or offer opinions in a case without talking to the individuals involved?
There are many areas across the spectrum of forensic psychiatry where interviews are not done, and in certain instances, they're not even possible. And in certain instances, you're actually allowed to give a diagnosis even without an interview when you are not given access to someone, but you have a complete record. The objective is for you to make an evidence-based determination that's inclusive of all the evidence that can be made available to you. If you don't have enough information, you don't offer an opinion. But if you have enough information and it's inclusive of all the information that's possible, then there are various areas in the forensic psychiatry arena where you do.
Stop you as well. You're beyond the scope of the question. If you want to ask him the question again directly and give a direct answer without moving into other areas.
Is offering an opinion in a case where you have not personally interviewed the individuals involved something that you do regularly?
It's something that forensic psychiatrists do as a matter of commonplace practice.
Thank you. Nothing further, Your Honor. We will reserve the witness.
Ladies and gentlemen, I think we'll go ahead and take our afternoon break at this time. Doctor, you're being reserved. The attorneys will stay in contact with you and let you know if you're going to be recalled, but you're free to step down as soon as the jury departs.
Okay, thank you.
All rise.
You may step down. Don't discuss your testimony with any of the other witnesses during the break. And again, the attorneys will stay in touch with you and let you know if you need to return. Counsel, 15-minute recess.
Thanks, Judge.